So, welcome to another explainer. Have you ever actually stopped to wonder what holds a country together? And I'm not talking about, shared culture or geography here, but the invisible structural framework. The rules that dictate who holds power, how they use it, and importantly, how we as citizens are protected from it. Today, we're unpacking the incredibly complex and honestly fascinating world of the UK Constitution and public law. Think of this whole system as the architectural blueprint of the state. It's the foundational design that keeps the entire shebang standing. This structure has evolved over literally centuries, and as we're going to see, it directly dictates the dimensions of your everyday life.
Okay, let's dive right into this. Here's our roadmap for today. First up, what is public law? Then, pillars of the Constitution. Third, checking executive power. Fourth, the human rights debate. And finally, public law in daily life.
All right, Section 1. What is public law? Defining the rules.
So, according to the Public Law Project, public law is, at its core, the set of rules governing how public bodies, think government ministers, local authorities, state agencies, interact with private individuals or organizations. Basically, if you've ever dealt with social services or maybe applied for planning permission or relied on state education, you've engaged with public law. It's essentially the rulebook for the state's interaction with us, the public.
Now, to really grasp this, it actually helps to see what it isn't. As Lord Woolf brilliantly pointed out, private law is the system that safeguards your rights against another private individual, like a standard business contract or, say, a property dispute with your neighbor. Public law, on the other hand, is uniquely designed to hold public authorities to account for their conduct. The key takeaway here is that the state just isn't treated like an ordinary defendant. It wields unique, massive powers, so it has to be governed by a unique set of rules to prevent any abuse of that power. Though, of course, in the real world, these two systems can and do sometimes overlap.
Moving right along, Section 2. Pillars of the Constitution, Structural Foundations.
Now, what's really interesting about this is that the UK actually lacks a single supreme codified document you can point to and say, yep, there's the Constitution. Instead, it has an uncodified constitution. It's this highly flexible, living mix of different sources. You've got statutes, which are acts of parliament. You've got common law made by judicial decisions. There are constitutional conventions, which are unwritten political practices. And then there's the royal prerogative, which refers to the historic administrative powers exercised by the Crown's ministers.
But despite this complex, centuries-old mix of diverse sources, there are exactly three core principles that buttress the legitimacy of this entire unwritten constitution. Let's look at what they actually are.
These three principles, they are the absolute bedrock of the system. First, parliamentary sovereignty. This means Parliament can literally make or unmake any law, and no one can legally override it. Second, the rule of law. This ensures that absolutely no one, not even the highest official, is above the law. And third, the separation of powers. This divides the state into distinct roles. Think of it kind of like a game, right? The legislature, Parliament, makes the rules. The executive, the government, plays the game. And the judiciary, the courts, acts as the independent referee to make sure absolutely no one steps out of bounds.
Which perfectly sets up Section 3, checking executive power, balancing the state.
This brings us to a really powerful quote from Lord Bingham, which perfectly illustrates the very core of the rule of law. He stated that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made. This spirit, it dates all the way back to the Magna Carta in 1215 and the rulings of Sir Edward Coke way back in 1610, establishing that you simply cannot exercise coercive power without proper constitutional authority.
But remember what we said earlier, the UK lacks a written constitution to strike down laws. So how does the judiciary actually act as that referee? Well, they use a mechanism called judicial review. Back in 1984, Lord Diplock laid out three clear grounds for this: illegality, irrationality, and procedural impropriety. It's important to note here, judges don't look at whether a government policy is a good idea. That's for voters to decide, right? They only look at whether the executive stayed within the legal limits and used the correct procedures set by Parliament.
A perfect, highly visible modern example of this tension can be seen in the recent Miller cases surrounding Brexit. Now, these were intensely controversial, but from a purely constitutional standpoint, they were simply testing the limits of executive power. Ultimately, the courts ruled that government ministers could not use their historic royal prerogative powers to frustrate or bypass the legislation that had already been passed by Parliament. It was a classic, real-time demonstration of the courts ensuring the executive answers directly to the legislature.
On to Section 4, the human rights debate, courts versus politicians.
Let's look at this timeline to really understand this ongoing political tug-of-war. In 1998, the Labour government enacted the Human Rights Act, which essentially embedded the European Convention on Human Rights right into domestic law. But this has faced significant pushback over the years. By 2011, the coalition government was already investigating a replacement. And in 2022, the Conservative government formally proposed a Bill of Rights bill to replace the Human Rights Act entirely, aiming to rebalance the power dynamics between the legislature and the courts.
So let's break down why this is such a fierce political flashpoint. On one side of the aisle, critics argue the Human Rights Act diminishes parliamentary sovereignty and hands far too much power to unelected judges, basically allowing them to dictate policy. But on the other side, supporters argue it is absolutely essential for protecting civil liberties, safeguarding minorities, and maintaining international legal standards. Specific flashpoints, things like prisoner voting rights and immigration deportations under Article 8, have caused massive friction. It even led parts of the tabloid press to controversially label judges as enemies of the people just for applying the law. Ultimately, it's a profound debate over exactly where the ultimate power in the state should lie.
Finally, Section 5, public law in daily life, impacting everyday spaces.
And this vividly illustrates exactly what I mean. Public law isn't just some abstract debate reserved for politicians and judges in grand halls. It governs the most basic, fundamental services we all rely on. Whether it's a local authority deciding on your housing accommodation, the Department for Work and Pensions awarding or denying welfare benefits, the granting of planning permissions, or even decisions on state school closures, these are all acts of public law. Every single one of these actions is subject to the rule of law and those exact principles of judicial review we just talked about.
To see how absolutely crucial this is today, let's look at contemporary research on what scholars are calling housing intensification, the reality of humans living increasingly, as they put it, cheek by jowl. Accelerated urbanization, global real estate markets, and the incredibly high cost of living are forcing denser, high-rise, and often overcrowded living conditions. And this isn't just an economic issue, it creates massive new social pressures that public law literally must regulate to maintain order and justice.
Let's see how this builds into real-world inequality. Consider delegated legislation like the nationally described Space Standard, which provides guidelines on minimum housing sizes. Because this is managed locally, researchers note it creates what's called territorial injustice. Basically, a home size that gets approved in one city might be completely rejected in another. And the stakes here are quite literally life and death. The COVID-19 pandemic tragically proved this, as severe health inequalities and avoidable deaths were directly linked to overcrowded housing and a lack of domestic space. The abstract rules of public law literally govern the breathing room we have in our own homes.
So how does the state respond to these modern pressures? Well, through new legislation, like the Renters' Rights Act. This is a prime example of public law attempting to re-regulate a previously deregulated market. It's trying to balance free markets, control antisocial behavior in dense living spaces, and provide real stability for tenants. Crucially, it shifts the burden of enforcement directly onto local authorities using civil penalties. It's a real-time, everyday example of the executive using statutory powers granted by Parliament to manage the intense realities of modern urban living.
Which brings us to our final thought. We've journeyed all the way from the ancient principles of the Magna Carta to the pressing, very modern realities of housing intensification and human rights debates. Our unwritten Constitution has survived centuries, mostly because of its incredible flexibility. But here's the question you should take away from this explainer. As our society becomes increasingly dense, complex, and intensified, is an unwritten, flexible Constitution robust enough to protect our evolving human rights? Or do the sheer challenges of the modern world require a new, codified blueprint? Thanks for joining this explainer, and keep questioning the foundations of the world around you.